coal allocation scam is a major political scandal concerning the Indian government's allocation of the nation's coal deposits to public sector entities and private companies. In a draft report issued in March 2014, the Comptroller and Auditor General of India Office accused the Government of India of allocating coal blocks in an inefficient manner during the period 2004–2009. Over the summer of 2012, the opposition BJP lodged a complaint resulting in a Central Bureau of Investigation probe into whether the allocation of the coal blocks was in fact influenced by corruption. The essence of the CAG's argument is that the government had the authority to allocate coal blocks by a process of competitive bidding, but chose not to. As a result, both public sector enterprises and private firms paid less than they might have otherwise. In its draft report in March, the CAG estimated that the windfall gain to the allocates was to the first 10,673 billion. The CAG Final Report tabled in Parliament put the figure at to the first 1856 billion on August 27, 2012. Indian Prime Minister Manmohan Singh read a statement in Parliament rebutting the CAG's report both in its reading of the law and the alleged cost of the government's policies. While the initial CAG report suggested that coal blocks could have been allocated more efficiently, resulting in more revenue to the government, at no point did it suggest that corruption was involved in the allocation of coal. Over the course of 2012, however, the question of corruption has come to dominate the discussion. In response to a complaint by the BJP, the Central Vigilance Commission directed the CBI to investigate the matter. The CBI has named a dozen Indian firms in a first information report, the first step in a criminal investigation. These FIRs accuse them of overstating their net worth, failing to disclose prior coal allocations, and hoarding rather than developing coal allocations. The CBI officials investigating the case have speculated that bribery may be involved. The issue has received massive media reaction and public outrage. During the monsoon session of the Parliament, the BJP protested the government's handling of the issue, demanding the resignation of the Prime Minister and refused to have a debate in the Parliament. The deadlock resulted in Parliament functioning only 7 of the 20 days of the session. The Parliamentary Standing Committee report on coal and steel states that all coal blocks distributed between 1993 and 2008 were done in an unauthorized manner, and allotment of all mines where production is yet to start should be cancelled. In 2015, coal auction helped state government earn 80,000 crore after sales of 11 coal blocks. 1992 Euro 2010. Background to Coalgate, history of coal allocation in India. The coal allocation process a OE in July 1992 Ministry of Coal, issued the instructions for constitution of a screening committee for screening proposals received for captive mining by private power generation companies. The committee was composed of government officials from the Ministry of Coal, the Ministry of Railways, and the relevant state government. A number of coal blocks, which were not in the production plan of CIL and SSCL, were identified in consultation with CIL-SSCL, and a list of 143 coal blocks were prepared and placed on the website of the MoSI for information of public at large. Coal allocation guidelines The guidelines for the screening committee suggest that preference be given to the power and steel sectors. They further suggest that in the case of competing applicants for a captive block, a further 10 guidelines may be taken into consideration: status, level of progress and state of preparedness of the projects. Net worth of the applicant company. Production capacity as proposed in the application. Maximum recoverable reserve as proposed in the application. Date of commissioning of captive mine as proposed in the application. Date of completion of detailed exploration as proposed in the application. Technical experience. Recommendation of the administrative ministry concerned. Recommendation of the state government concerned. Track record and financial strength of the company. Results of the coal allocation program. The response to the allocation process between 2003 and 2009 was spectacular, with some 44 billion metric tons of coal being allocated to public and private firms. By way of comparison, the entire world only produces 7.8 billion tons annually, with India being responsible for 585 million tons of this amount. Under the program, then, captive firms were allocated vast amounts of coal, equating to hundreds of years of supply, for a nominal fee. Out of the above 216 blocks, 24 blocks were allocated for non-performance of production by the allocates, and 2 allocated blocks were subsequently reallocated to others. Hence, 194 coal blocks, with aggregates geological reserves of 44.44 billion metric tons, stood allocated as at March 31, 2011. Source: Draft CAG Report, Table 5.1. Given the inherent subjectivity in some of the allocation guidelines, as well as the potential conflicts between guidelines, it is unsurprising that in reviewing the allocation process from 1993 to 2005 the CAG says that there was no clearly spelt out criteria for the allocation of coal mines. In 2005 the Expert Committee on Coal Sector Reforms provided recommendations on improving the allocation process, and in 2010 the Mines and Minerals Act, 1957 Amendment Bill was enacted, providing for coal blocks to be sold through a system of competitive bidding. The foregoing supports the following conclusions: the allocation process prior to 2010 allowed some firms to obtain valuable coal blocks at a nominal expense. The eligible firms took up this option and obtained control of vast amounts of coal in the period 2005–09. The criteria employed for awarding coal allocations were opaque and in some respects subjective. March 2012. Draft CAG Report on Coalgate, Overview. The CAG report, leaked to the press in March as a draft and tabled in Parliament in August, is a performance audit focusing on the allocation of coal blocks and the performance of Coal India in the 2005–09 period. The draft report, stretching to over 100 pages, far more detailed and containing more explosive allegations than the toned-down final report of some 50 pages, was the document that sparked the Coalgate furor. The draft report covers the following topics: overview, audit framework, institutional framework, gaps in supply and demand, coal blocks allocation and production performance of CIL, conclusion and recommendations, annexures. As far as Coalgate is concerned, the key passages of the draft report are in Chapter 5, where the CAG charges that, in 2005 the government had the legal authority to allocate coal blocks by auction rather than the screening committee, but chose not to do so. As a result of its failure to auction the coal blocks, public and private companies obtained windfall gains of to the first 10,673 billion, with private companies obtaining to the first 47.95 billion and government companies obtaining to the first 50.78 billion. The most important assertion of the CAG draft report is that the government had the legal authority to auction the coal, but chose not to do so. Any losses as a result of coal allocations, then, between 2005 and 2009 are seen by the CAG as being the responsibility of the government. The answer to this question turns on whether the government could institute competitive bidding by an administrative decision under the current statute or whether it needed to amend the statute to do so. The CAG devotes 10 pages of its report to reviewing the legal basis for an auction, and comes to the following conclusion: in sum, there were a series of correspondences with the Ministry for Law and Justice for drawing conclusion on the legal feasibility of the proposed amendments to the CMN Act MMDA Act or through administrative order to introduce auctioning competitive bidding process for allocation of coal blocks for captive mining. In fact, there was no legal impediment to introduction of transparent and objective process of competitive bidding for allocation of coal blocks for captive mining as per the legal opinion of July 2006 of the Ministry of Law and Justice, and this could have been done through an administrative decision. However, the Ministry of Coal went ahead for allocation of coal blocks through screening committee and advertised in September 2006 for allocation of 38 coal blocks and continued with this process until 2009. Other parts of the report, however, suggest that while an administrative decision might be sufficient legal basis for instituting competitive bidding, the legal footing of competitive bidding would be improved if the statute were amended to specifically provide for it. That is, there were some questions around the legality of using an administrative decision as the ground for an auction process under the current statute. Quoting the Law Secretary in August 2006, There is no express statutory provision providing for the manner of allocating coal blocks. It is done through a mechanism of inter-ministerial group called the Screening Committee. The Screening Committee had been constituted by means of administrative guidelines. Since, under the current dispensation, the allocation of coal blocks is purely administrative in nature, it was felt that the process of auction through competitive bidding can also be done through such administrative arrangements. In fact, this is the basis of our earlier legal advice. This, according to the Administrative Ministry, has been questioned from time to time for legal sanction. If provision is made for competitive bidding in the Act itself or by virtue of rules framed under the Act, the bidding process would definitely be placed on a higher level of legal footing. So while the CAG certainly makes the case that the government had legal grounds on which to introduce competitive bidding into the coal allocation process, saying that there was no legal impediment to doing so perhaps overstates their case. Second CAG charge, windfall gains to the allocates were to the first 10,673 billion if the most important charge made by the CAG was that of the government's legal authority to auction the coal blocks, the one that drew the most attention was certainly the size of the windfall gain accruing to the allocates. On pages 32-34 of the draft report, the CAG estimates these to be to the first 10,673 billion with details in the following table. The table employs the following calculations for windfall gain. Windfall gain ton equals market price ton euro production cost ton. Windfall gain equals windfall gain ton x number of tons allocated x 90%. Note that while the windfall gain ton is fairly modest to the first 322, because of the vast size of the coal allocations, the total figure for the windfall gain is very large. Note also that the figure stated as a windfall gain would in fact accrue to the allocatee over the life of the reserve, which would likely exceed 100 years. Thus, using any reasonable discount rate, the present value of the windfall gain will be dramatically smaller of the windfall gain stated in the CAG report. While the headline number of to the first 10,673 billion was sure to attract the attention of the public, in the annexures to the report the CAG listed the windfall gains by company, allowing readers to see who exactly benefited from the allocation program, and by how much. The resulting list, a veritable who's who of Indian commerce, ensured that the topic of coal allocations would be one of the most written about stories of 2012. March August 2012. Coalgate grows, the media, the BJP, and the CBI and income tax investigation. On March 22, The Times of India broke the story on the contents of the draft CAG report. New Delhi, the CAG is at it again. About 16 months after it rocked the UPA government with its explosive report on allocation of 2G spectrum and licenses, the Comptroller and Auditor General's draft report titled Performance Audit of Coal Block Allocations says the government has extended undue benefits, totaling a mind-boggling Rs 10.67 trillion, to commercial entities by giving them 155 coal acreages without auction between 2004 and 2009. The beneficiaries include some 100 private companies, as well as some public sector units, in industries such as power, steel and cement. The Income Tax Department was also roped in to look into the financial frauds and follow the money trail. The story listed the following companies as the leading beneficiaries of the coal allocations. Allegations against S. Jagathrak Shaken equals. In September 2012, several news reports alleged that family of S. Jagathrak Shaken, Minister of State for Information and Broadcasting in the UPA government, is a part of a company named Junior Power General Private Ltd, which was awarded a coal block in Odisha in 2007. It was the same company which formed a joint venture with a public sector company, Puducherry Industrial Promotion Development and Investment, on January 17, 2007. Barely 5 days after, Pipedick was allotted a coal block. According to the MOU, Junior Power enjoyed a stake in this allotment. However, Junior Power had no expertise in thermal power, iron and steel, or cement, the key sectors for consumption of coal. Later, in 2010, Junior Power sold 51% stake to KSK Energy Ventures, an established player with interests in the energy sector. In this way, the rights for the use of the coal block ultimately passed on to KSK. Reacting to this, Jagath Rakshakhan admitted to getting a coal block, and said that, "It is true that we got a coal allocation, but it was a subcontract with Puducherry government and then we gave it away to KSK company. Now, we have got nothing to do with the allocation, but if the government wants to take back the allocation it can do so." Allegations against Subodh Sahay. In September 2012, it was revealed that Subodh Sahay, tourism minister in the UPA government, sent a letter to Prime Minister Manmohan Singh trying to persuade him for allocation of a coal block to a company, SKS Ispat and Power, which has Subodh Sahay, his younger brother, as honorary executive director. The letter was written on February 5, 2008. On the very next day, Prime Minister's office sent a letter to the Coal Secretary on February 6, 2008, recommending allotment of coal blocks to the company. However, Sahay denied these allegations, citing that the coal block was allocated to SKS Ispat, where his brother was only an honorary director. On September 15, 2012, an inter-ministerial group headed by Zohra Chatterjee recommended cancellation of a block allotted to SKS Ispat and Power. Allegations against Ajay Sankheti and his link with Nitin Gaikwari. Ajay Sankheti's SMS Infrastructure Limited was allegedly allocated coal blocks in Chhattisgarh at low rates. He is a BJP Rajya Sabha MP and is believed to be in close relation with Nitin Gaikwari. According to the CAG, the allocation of the coal block to SMS Infrastructure Limited has caused a loss of Rs 10 billion. Allegations against Vijay Dada and Rajendra Dada. Vijay Dada, a Congress MP, and his brother Rajendra Dada, the Education Minister of Maharashtra, have been accused of direct and active involvement in the affairs of three companies: JLD Yavatmal Energy, James Infrastructure and Power Limited, AMR Iron and Steel Private Ltd., which received coal blocks illegally by means of inflating their financial statements and overriding the legal tender process. Allegations against Premchand Gupta. UPA partner Rashtriya Janata Dal's leader Premchand Gupta's son's company, new in the steel business, applied for a coal block when Premchand Gupta was the Union Minister for Corporate Affairs and secured it about a month after his tenure ended, along with that of his government. The company in question is IST Steel and Power, an associate company of the IST Group, which is owned and run by Premchand Gupta's two sons Mayor and Gaurav. IST Steel, along with cement majors Gujarat Ambuja and Lafarge, was allocated the Dahgaon Magadhokra 4 block in Maharashtra. The company, which applied for a block on January 12, 2007, and was awarded it on June 17, 2009, is sitting on reserves of 70.74 million tons. The reserves it controls are more than the combined reserves held by much larger companies Gujarat Ambuja and Lafarge. Gupta, who belongs to the Rashtriya Janata Dal headed by Bahar leader Lalu Prasad Yadav, was the Minister of State for Corporate Affairs in UPAI when his party was a constituent of the Congress-led coalition with 21 seats in Lok Sabha. However, Mr. Gupta maintains he had no involvement in IST Steel and denies influencing the coal block allocation process. Allegations against Naveen Jindal. Congress MP Naveen Jindal's Jindal Steel and Power got a coal field in February 2009 with reserves of 1,500 million metric tons, while the government-run Navratna Coal India Limited was refused. On February 27, 2009, two private companies got huge coal blocks. Both the blocks were in Orissa, and while one was over 300 megametric tons, the other was over 1,500 megametric tons. Combined worth of these blocks was well over Rs 2 trillion, and these blocks were meant for the liquefaction of coal. One of these blocks was awarded to Jindal. Naveen Jindal's Jindal Steel and Power was the company which was allotted the Talcher coalfield in Angle in Orissa in 2009, well after the self-imposed cut-off date by the centre on allocation of coal blocks. The opposition alleged that the government violated all norms to give him coal fields. Naveen Jindal, however, denied any wrongdoing. On September 15, 2012, an inter-ministerial group headed by Zohra Chatterjee recommended cancellation of a block allotted to JSW, a Jindal Group company. On June 11, 2013, CBI has booked former Minister of State for Coal Dasari Narayan Rao and Congress MP Naveen Jindal for alleged cheating, graft and criminal misconduct in its 12th FIR in the coal blocks allocation scam. BJP response In response to the Times of India story, there was an uproar in Parliament, with the BJP charging the government with corruption and demanding a court-monitored probe into coal allocations. The CWG scam is of Rs 700 billion, 2G scam is Rs 1.76 trillion. But, now the new coal scam is Rs 10.67 trillion. It is a government of scams. From airwaves to mining, everywhere the government is involved in scams, party spokesperson Prakash Javadekar told reporters. CBI and income tax investigation On May 31, 2012, Central Vigilance Commission based on a complaint of two Bharatiya Janata Party Member of Parliament Prakash Javadekar and Hans Raja directed a CBI inquiry. Income Tax Department also started an inquiry based on the reference by the two BJP MPs. There were leaks of the report in media in March 2012 which claimed the figure to be around to the first 10,600 billion. It is called by the media as the mother of all scams. Discussion about the issue was placed in the Parliament on August 26, 2012 by the Prime Minister Manmohan Singh with wide protests from the opposition. According to the Comptroller and Auditor General of India, this is a leak of the initial draft and the details being brought out were observations which are under discussion at a very preliminary stage. On May 29, 2012, Prime Minister Manmohan Singh offered to give up his public life if found guilty in this scam. Formation of Inter-Ministerial Group At the end of June 2012, Coal Ministry decided to form an inter-ministerial group, to decide on either deallocation or forfeiting the bank guarantees of the companies that did not develop allotted coal blocks. Zohra Chatterjee, Additional Secretary, Coal Ministry, was named as chairman of the IMG. Other IMG members include representatives from Power, Steel, Departments of Economic Affairs, Industrial Policy and Promotion, and Law and Justice. Significantly, the decision was taken after the CVC had already ordered a CBI inquiry into alleged irregularities. As of September 26, 2012, the IMG has reviewed 31 coal blocks. Out of these, it has recommended the allocation of 13 coal blocks and encashment of bank guarantees of 14 allocatees. The Coal Ministry on Thursday decided to allocate 11 captive coal blocks including 3 mines of Jindal Steel and Power, besides forfeiting the bank guarantees of 6 firms and asking 5 to expressly furnish bank guarantees. The ministry has been facing intense flak over alleged irregularities in allocation of coal blocks since 1993, and the Central Bureau of Investigation is currently investigating the abnormalities and criminal conspiracy in their allotment. The agency has filed 14 FIRs and 2 preliminary inquiries so far in this connection. In this backdrop, an inter-ministerial group of the Coal Ministry met on October 24 to consider the fate of 30 coal blocks, including those being investigated by the CBI. Of the mines recommended for deallocation, 2 blocks Amarkand Amergad Angle and Ramkhandi Promotional belongs to Naveen Jindal promoted JSPL, and the Erton North block also allocated to JSPL along with Monitor Ispat and Energy. All allocatees had been issued show-cause notices and were asked to furnish their views to the IMG. The decisions have been taken after careful consideration, a top Coal Ministry official told the Indian Express. Coal Minister Sri Prakash Aiswal has learned to have approved the recommendations of the IMG. Another coal-to-liquid block north of Akrapal allocated to the Strategic Energy Tech System Limited, which is a joint venture between the Tata Group and South African firm Sasol, has also been deallocated. The Radhikapur block allocated jointly to Rungta Mines, OCL India and Ocean Ispat, Bikram Mine allotted to Bla Corporation, Kappa and Extension block allocated to Sunflag Iron and Steel and Dalmia Cement have been cancelled. The ministry has decided to deallocate the Rajamadipside coal block jointly allotted to Monitor Ispat and Energy Limited among others. With a fresh round of deallocation, the total number of blocks cancelled stands at 51 as the government had earlier deallocated 40 blocks. The ministry is preparing to inform the companies impacted by the decision. As per the IMG's recommendation, steelmaker SAIL is among the 5 companies to lose bank guarantees for delay in developing allotted blocks. Other firms include Allocating Infrastructure, Andhra Pradesh Mineral Development Corporation, Tenuhot Vidyut Nigam and Common Deallocated blocks, companies Coal Blocks State Jindal Steel and Power Amarkand Amarga Dangle Jharkhand, Jindal Steel and Power Ramkhandi Promotional Block, CTL. Orissa Jindal Steel and Power and Ertan North Madhya Pradesh, Monnet Ispat and Energy Rungta Mines, OCL India Radhikapur Orissa and Ocean Ispat, Strategic Energy Tech System North of Akrapal Orissa Limited, BLA Corporation Bikram Madhya Pradesh Sunflag Iron and Steel Kappa and Extension Maharashtra and Dalmia Cement Monnet Ispat and Energy Rajagamardipsite Chhattisgarh and Shri Virangana Steels Limited, Rathi Udyog Limited Kessler North Chhattisgarh. Kastran Bramdih Jharkhand, Maharashtra State Mining Corporation Warora Maharashtra. Meanwhile, Jindal Steel and Power Limited intends to appeal in court against the government decision to deallocate the coal block allocated to it, a company source said. A JSPL spokesperson earlier said the company sees a owner Sonia behind the deallocation as environment clearance for the coal block in Chhattisgarh was given on February 10. Sources in the Coal Ministry said the IMG has sent a note to the ministry recommending deallocation of 11 coal blocks of companies including JSPL, Monnet Ispat and Energy Limited and either imposition or deduction of bank guarantee in another 19 cases. A large varieties of these blocks were issued show cause notices by the IMG to show why they had failed to take the required action to develop these blocks and why action should not be taken against them. Following this, the Coal Ministry had asked the owners of these blocks to make a presentation before the IMG on achievement of milestones and reasons for delays. Those who were asked to make a presentation before the IMG included State-owned Steel Authority of India, NTPC Limited, JSPL, Abhijit Infrastructure, BLA Corporation and Rathi Udyog, Tata Power and Monnet Ispat and Energy Limited. JSPL was specifically asked to make a presentation with regard to delay in production from its 4 coal blocks, Amarkand Amarga Dangle in Jharkhand, Utkal B1 and Ramkhandi in Odisha and Ertan North in Madhya Pradesh. Similarly, SAIL was asked to make presentation for Saikanala Mine in Jharkhand and NTPC for Paki Bawadi Mine in Jharkhand and Talaipalli Mine in Chhattisgarh. During the presentation, a number of companies pointed to the continued unending delays in land acquisition, getting environmental clearances and regulatory hurdles for delays in development of the mines. The government had formed the IMG last year to review the progress of coal blocks allocated to firms for captive use and recommend action, including deallocation. The panel has members from other ministries including Steel and Power. The Supreme Court is monitoring the Coalgate scam probe into coal block allocation since 1993 being conducted by CBI following 3 public interest litigation petitions alleging that rules were flouted in giving away the natural resources and favouring certain companies at a huge loss of crores to the national exchequer. Slamming the decision to deallocate their coal blocks, Jindal Steel and Power and Monnet Ispat and Energy have blamed lack of government approvals and external factors like Naxal activities for not making enough progress in their mines. The 2 companies, whose 4 blocks figure in the list of 11 to be deallocated, said that they are being punished for no fault of theirs. The deallocation is seen as a major setback to both as the blocks were supposed to be the captive raw material source for their upcoming existing steel and power plants. Jindal's Rs 80,000 crore mega venture of coal-to-liquid project is likely to be hit. The 2 companies have together invested over 110 billion so far on development of their end-use plants. At the outset, we are shocked and surprised to hear the recommendation made by IMG. It seems that everybody in the policy-making monitoring wants to avoid a pragmatic decision in view of the media hype, Monnet Ispat spokesperson said in a statement. The JSPL spokesperson said the company's coal blocks are being deallocated despite best efforts made by the company and no fault on part of the company. Last week, the Coal Ministry decided to allocate 11 captive coal blocks to various companies. JSPL's 3 euro Ramkhandi promotional block, the Markanda Murga Dangle and Erton North euro figure in the list. Monit's one more block, Rajagamardipside coal block jointly allotted to Monit Ispat and Energy Limited among others, is also part of the list. The Monit spokesperson further said 450 hectares of the block, out of total 650 hectares, is overlapping with a block of the Southeastern Coalfields Limited and SECL needs to surrender title of the land and transfer it to Monit. He also accused the Coal Ministry of violating its own conditions, saying that the clause clearly stipulates that any delay in transferring the land by a government company to the coal block allocatee can be claimed as grace period. A Euro if IMG has recommended for allocation, then they are violating the published guidelines of MoC, the spokesperson said, adding that Monit can start development of the block immediately as it needs to acquire only 5 acres of land for making an entry. According to the JSPL spokesperson, the company has made 4 attempts for carrying out exploration at Markanda Murga Dangle block since April 2009 but could not do it due to large amount of extremist Naxal activities, and illegal mining supported by extremists' anti-social elements. State government had further agreed to extend the validity of PL by 2 years 4 months and 8 days under force majeure conditions on June 5, 2013 and we are in the process of starting our 5th attempt to carry out drilling operations in this block, he said. The spokesperson of Jindal Steel and Power said its employees, officials and contractors were assaulted or made hostage many times at the site and equipment were damaged. He added that many complaints and FIRs have been filed on these issues and state and central governments have been informed about it. Talking about the to be allocated Ramkhandi promotional block, he said JSPL's application for prospecting license is pending with the Odisha government for more than 3 years and the state government has not yet executed PL on one pretext or the other in spite of a number of reminders. A Euro in the circumstances, company could not start exploration activities for no fault of the company, he said, while noting that the company has already completed various initial work, including detailed feasibility study, for the project and has invested Rs 740 million on it. The Ramkhandi block, which has estimated 1.5 billion tons of coal reserves, was allocated for ambitious coal-to-liquid project in February 2009 and JSPL had already announced investment Rs 800 billion on the venture. On Erton North Block, the third to be allocated block, JSPL spokesperson said that its mine plan is pending for final approval from Coal Ministry for more than 6 months now. The delay in Coal Ministry's approval has led to further delay in securing environment clearance as well. Expert Appraisal Committee of MoEF, GOI has already considered grant of EC and is mainly pending for submission of mine plan approval letter. The mine plan approval letter is pending for issuance with Ministry of Coal for more than 6 months, the company said. Monit, which is also a partner in the block, also echoed the same. The spokesperson said that grant of EC is in the final stage, and the company is hopeful that it will be cleared by EAC in their forthcoming meeting to be held later this month. For Monit, Erton North and Rajagamardipside blocks are supposed to be the captive raw material source for its over 1 million-ton steel plant in Chhattisgarh's Raigarh, which is now in final stages of commissioning. The company said it has invested over Rs 60 billion to develop the end-use plant. The Erton North block is also critical to JSPL's plans as it was supposed to meet 10 to 12% of the coking coal needs of its already operational Raigarh steel plant in Chhattisgarh. The company said has invested Rs 34.16 billion on its development. August 2012. Colgate reaches Parliament, the final report and Manmohan Singh's rebuttal in Parliament. The CAG Final Report Overview. On August 17 the CAG submitted its final report to Parliament. Much less detailed than the draft report, the final report still made the same charges against the government. The government had the authority to auction the coal blocks but chose not to. As a result, allocates received a windfall gain from the program. The final report had the following outline. Preface. Executive Summary, Chapter 1. Koala Euro an Overview, Chapter 2. Audit Framework, Chapter 3. Augmentation of Coal Production, Chapter 4. Allocation of Captive Coal Blocks, Chapter 5. Productive Performance of Captive Coal Blocks, Chapter 6. Conclusion and Recommendation. First CAG charge, the government had the legal authority to auction coal blocks. In Chapter 4 of the final report, the CAG continued its contention that the government had the legal authority under the existing statute to auction coal by making an administrative decision, rather than needing to amend the statute itself. Pages 22–27 chronicle key correspondence between the Secretary, the Minister of State, the Prime Minister's Office, and the Department of Legal Affairs from 2004 to 2012. From this record, the CAG draws the following conclusions. The government decided to bring transparency and objectivity in the allocation process of coal blocks, with June 28, 2004 taken as the cut-off date. The DLA advice of July 2006 was sufficient grounds upon which to introduce competitive bidding, by means of an administrative decision. Despite this DLA advice, there was prolonged legal examination as to whether an administrative decision or amendment of the statute was necessary for competitive bidding to be introduced. This stalled the decision-making process through 2009. In the period between July 2006 and the end of 2009, 38 coal blocks were allocated under the existing process of allocation, which lacked transparency, objectivity, and competition. Second CAG charge, windfall gains to the allocates were to the first 1856 billion. The biggest change from the draft report was the dramatic reduction in the windfall gains from a to the first 10,673 billion to a to the first 1856 billion. This change is due to, windfall gain ton decreased 8% from a to the first 322 in the draft report to a to the first 295 in the final report, number of tons decreased 81% from 33.169 to 6.283 billion metric tons of coal. This is because the final report considers extractable coal as against the draft report, which considered coal in situ. Source: CAG Final Report, pages 31. Note: these are still huge coal volumes compared to India's annual production and represent many decades of the actual coal needs of the captive firms. The headline number of a to the first 1856 billion is the gain that would accrue to captive firms over these decades, and there is no attempt to derive a present value of the gain. However, considering inflation rate equaling discount rate, the gain calculated reflects the nearly accurate value. Manmohan Singh's rebuttal in Parliament equals. Overview: West Bengal, Chhattisgarh, Jharkhand, Orissa and Rajasthan that were ruled by opposition parties, was strongly opposed to a switchover to the process of competitive bidding as they felt that it would increase the cost of coal, adversely impact value addition and development of industries in their areas and would dilute their prerogative in the selection of lessees. The CAG, Singh argued, had simply ignored the practical realities of policy implementation in their accusation that the government did not move fast enough in transitioning to competitive bidding. First CAG charge, the government had the legal authority to auction coal blocks. Singh addresses the question of legal authority in paragraphs 14–18 of his parliamentary statement. Second CAG charge, windfall gain to the allocates were to the first 1856 billion. Role of Sonia Gandhi on August 31, Manmohan Singh met UPA chairperson Sonia Gandhi and communicated to her that his office had cleared the coal block allotment on the recommendation of her political secretary Ahmed Patel. Washing his hands of the tainted coal block allotment, Dr. Singh made it clear to Sonia Gandhi that he had no role or interest in determining who the beneficiaries should be. PM explained that his then Principal Secretary Tka Nair had merely coordinated the allotment decision as desired by Ahmed Patel. Ahmed Patel is one of Sonia Gandhi's closest aides. He has been her political secretary since 2000, and she is known to rely on him greatly in the running of the Congress Party. September 2012. Colgate reaches Supreme Court of India. Advocate M.L. Sharma filed a public interest litigation in the Supreme Court seeking to cancel the allotment of 194 coal blocks on grounds of arbitrariness, illegality, unconstitutionality and public interest. Defending the CAG, a Supreme Court bench of Justices R.M. Lodha and A.R. Dave dismissed the Solicitor General Rohinton Nariman's objections that petition relies heavily on the CAG report by saying, the CAG is a constitutional authority, and that its report is not a piece of trash. Moreover, the court ordered the government to inform it of reasons for not following the 2004 policy of competitive bidding for coal block allocation. The apex court wanted to know not only the steps that have been taken but also proposed against companies that have breached the agreement. On March 13, 2013, Supreme Court bench responded to rare display of divergence between Centre and Premier Investigation Agency (CBI) by asking its director not to share details of coal block scam investigations with political executives and report only to the court. It further ordered the CBI director to file an affidavit by April 26 stating that probe status report filed before it had been vetted by him and its contents were not shared with the political masters, and the same arrangement shall follow in future. 2 applications were filed by NGO Common Cause and Manmohan Singh on April 13, 2013. Activist lawyer Prashant Bhushan sought creation of a special investigation team to probe the case as it involved very powerful personalities in the present government who were either in charge of the allocation process or who influenced the process to get allocation to their favored entities. There has been mounting evidence for the last 1 year as to how major corporate groups like Jindal's were able to garner huge blocks with millions of tons of coal, as was the case with shady companies linked with other politicians. Despite that, CBI has neither filed any charge sheet nor made an arrest. The application said the Navin Jindal Group had allegedly misrepresented facts and was shown favour by the Jharkhand government, which dropped other firms from its recommendation for allocation of coal blocks in the state in 2007. The CBI has said in its FIR filed before a court here in Colgate the FIR is categorical that Ministry of Power was against the proposal for allocating a Markandemerga Dangle coal block to Jindal Group firms Jindal Steel and Power Limited and Galgan Sponge Iron Private Ltd, which have been named as accused along with Congress MP Navin Jindal. However, former Minister of State for Coal Dasari Narayan Rao, also an accused in the FIR, had written a note to the then Coal Secretary and showed undue favour to Jindal's firm, which had misrepresented the facts regarding its preparedness in setting up their proposed end-used plant. Inquiry further revealed that Government of Jharkhand via its letter dated June 20, 2007 recommended the allocation of Markandemerga Dangle coal block to 3 companies, namely MS Lanco Infratech Limited, MSJSPL and MSGSIPL. However, via its letter dated July 30, 2007, Government of Jharkhand changed its recommendation and recommended the allocation of Markandemerga Dangle block to only the 2 Navin Jindal Group companies, that is JSPL and MSGSIPL, the CBI said in its 12th FIR filed till date in the coal blocks allocation scam before the special CBI court. The agency alleged that both SPL and GSIPL misrepresented the facts to the Coal Ministry, but the Screening Committee, which used to recommend for allocation of coal blocks to the shortlisted applicant companies, in its meeting held on September 13, 2007, had recommended allocation of Markandemerga Dangle coal block jointly to these 2 firms. Inquiry further revealed that both MSJSPL and MSGSIPL misrepresented in its application feedback form on account of their preparedness in setting up their proposed EUP as well the previous allocation of coal blocks to their group companies, it said. The FIR further said, despite not being recommended by the Ministry of Power and the companies having misrepresented on the aforesaid counts, the Screening Committee in its meeting held on September 13, 2007 recommended the allocation of Markandemerga Dangle coal block jointly to MSJSPL and MSGSIPL. The CBI said that Power Ministry had not recommended allocation of coal blocks either to JSPL or GSIPL as they did not meet the criteria of preparation adopted by Central Electricity Authority, which shortlisted the companies on behalf of Ministry of Power. Regarding Rao, the agency said that in order to influence the decision of the Screening Committee in favor of JSPL and GSIPL, The then Minister of State for Coal had written a note on July 27, 2007 to the Coal Secretary, who was also chairman of the screening committee. Referring to the note, CBI said, he mentioned that he had come to know through the media reports that Ministry of Power CEA had been appraising various applications received in the Ministry of Coal on the criteria of net worth of applicant, progress regarding land acquisition and water tie-up etc. However, the screening committee should evaluate various applicants as per the past practices. It said on a representation by another firm, Bush and Energy Limited, seeking 50% share in Amark and Amerga Dangle coal block. Rao again showed undue favour to Jindal's firms and justified the decision of screening committee recommending the allocation of coal blocks to the two companies. It said that JSPL had submitted its application for coal block allocation in January 2007 to the Coal Ministry for securing few blocks earmarked for power sector, including Amark and Amerga Dangle coal block in Jharkhand for its proposed 1000 MW captive power plant to be set up at Patratuxpal. Also submitted its application dated January 10, 2007 to the Ministry for its 1000 MW independent power plant in Dumka district in Jharkhand, the CBI said, adding that the allocation letter was issued to the two firms on January 17, 2008. Besides Jindal, Rao, JSPL and GSIPL, the accused named in the FIR, lodged under provisions of the IPC dealing with the offence of conspiracy to cheat and under the relevant sections of the Prevention of Corruption Act, area Euro members of the 35th Screening Committee, Jindal Realty Private Ltd, New Delhi Exim Private Ltd, Sobergia Media Limited, directors of GSIPL and other unknown persons. 2013. Role of Prime Minister Manmohan Singh. In 2004, Coal Secretary P.C. Parekh informed PM the potential fraud inherent in the discretionary allocation of the captive coal fields and objected to it in writing. Still, all the 142 coal blocks were allocated without auction during the Prime Minister's tenure in the Coal Ministry. BJP on April 19 demanded the resignation of Prime Minister Manmohan Singh, alleging that he was using the Law Ministry to save himself from the probe. The Supreme Court observations on April 30 are undoubtedly harsh. No other government in India has been criticised in such words. The legalities of the case have proved troublesome for Manmohan Singh and the UPA. P.C. Parekh, who is considered the whistleblower for the Colgate, said that he clearly pushed for auctions, but was overruled by the PM. Parliamentary Standing Committee report. Standing Committee on Coal and Steel tabled in Parliament on April 23, 2013 stated in its latest report that all coal blocks distributed between 1993 and 2008 were done in an unauthorised manner and allotment of all mines where production is yet to start should be cancelled. It recommended that all personnel, who have been involved directly or indirectly in the allocation process, should be investigated for their role. There was no transparency in the allocation process and the Exchequer did not get any revenue from allocation of the blocks. It has pointed out that the allocations between 1993 and 2004 were done without any advertisement or public information. It accused both the UPA and NDA for perpetrating massive corruption. Supreme Court hearing. On April 26 the CBI Director Ranjit Sinha submitted an affidavit in the Supreme Court stating that the coal scam status report prepared by the investigating agency was shared with the Law Minister Ashwani Kumar as desired by him, Joint Secretary-level officers from the Prime Minister's office and the Coal Ministry before presenting it to the court on March 8. It contradicts the claim made by CBI counsel in SC that the coal scam report was not shared with any member of the government. On April 29, CBI stated to SC that 20% of its original report was changed by government. Additional Solicitor General Harun Raval resigned for having misled the Supreme Court. Ranjit Sinha said SC that CBI is part of government and hence not autonomous. The three-judge bench of Justices R. M. Lodha, Madan B. Lokha and Kurian Joseph directed the CBI to file an affidavit by May 6 regarding the changes that were made in the status report, at whose instance the changes were made, and the effect of these changes on the entire investigation. Counsel Prashant Bhushan said there were efforts to shield PM. He said the Central Vigilance Commission can at least be asked to direct the CBI to show the final report. If the CVC feels there are a few things left out and if there are things not done, then it can ask the CBI to change the investigating officer. The reason why the CVC can interfere is because of this administrative control. The CBI director, who has statutory status, can be pressurized by promising post-retirement jobs etc. Thus government managed to control the CBI. ADV Prashant Bhushan said companies are trying to operationalize and then they can say so much investment is being done. Every delay will lend them the contention of equity. He requested court to appoint a retired judge and police officer of impeccable integrity to overlook the investigation. SE said that it will liberate CBI from political interference to make CBI credible, impartial and independent. On September 24, 2014, Supreme Court quashed allocation of 214 out of 218 coal blocks which were allotted to various companies since 1993 and in which it was claimed that around Rs2 lakh crores were invested. 2014 Special CBI Court In July 2014, Supreme Court of India decided to set up a special CBI court to try cases arising from coal block allocation scam. It also appointed Rajinder Singh Cheema, ex-Advocate General, Punjab, as the Special Public Prosecutor and Justice Bharat Parashar is the judge of the special court that will hear the case on a day-to-day basis. The court also directed that all the matters pending in different court relating to coal blocks allocation scam would stand transferred to the special court. Supreme Court verdict On September 24, Supreme Court of India decided to cancel 214 out of 218 coal blocks allocated since 1993. Apart from the cancellation, operational mines will have to pay a penalty of Rs 295 for every ton of coal extracted since they started. 2015. Summons issued and then stayed to Manmohan Singh and others. On March 11, 2015. Special CBI judge took cognizance of the offence under sections 120B and 409 of Indian Penal Code, 1860 and sections 13(1)(c), 13(1)(d), (e) of Prevention of Corruption Act, 1988 against Dr. Manmohan Singh and 5 other accused, namely Ms. Hindalko, Subindu Amitabh, D. Bhattacharya, Kumar Mangalambla, P.C. Parekh. It further took cognizance of substantive offences under sections 409 of IPC and sections 13(1)(c) and 13(1)(d), (e) of Prevention of Corruption Act, 1988 against Singh and Parekh. Court then issued summons to the 6 accused. Singh and Parekh then approached the Supreme Court, which on April 1, 2015 granted an interim stay against the order and stayed further proceedings against them before the special CBI court. Missing files. Coal allocation sections are responsible for maintaining all records pertaining to allocation of coal blocks. The number of missing files was initially pegged at 157 the number of applications for coal blocks allocation. Nearly 150 are related to the period between 1993 and 2004 in which 45 coal blocks were allocated. Missing files benefit 3 sets of fee or plea the beneficiary companies who received coal block allocations, the screening committee and the minister and his office. The BJP says that the bulk of the questionable allocations took place while PM Manmohan Singh held charge of the coal ministry. People in office during the allocations: TKA Nair, former Principal Sessi, PM and now advisor to PMDC Garg under CBI scanner. Ministers Sri Prakash Aiswal Manmohan Singh, UPAI Coal Minister Sabu Soren, May 2004 to 2007, except July 24 November 27 2004-2003 Ministry of Coal separated from Ministry of Mines. Ministers of Mines Mamata Banerjee AITC Ramvilas Paswan LJP SYED Shahnoz Hussain BJP Sundar Lal Patwa BJP Naveen Patnaik BJD. See also. References. External links: CAG's leaked draft report on coal mining, full text of CAG's letter to Prime Minister, upper unregistered trademark SA OE the zero loss theory, all the documents related to coal scam, ex-Jharkhand CM, 7 others summoned as accused.